Victim compensation scheme. So first we will try to understand who is a victim. So any person, group or entity who have suffered harm, injury or loss due to illegal activities of other. This harm may be economical, mental or physical. Thus any person who has suffered harm because of violation of criminal law is a victim. A person will be considered as victim even when the offender is not identified or prosecuted. The term victim also includes the individuals who have suffered harm as a result of assisting the victim in distress and prevent victimization. So not only the person who have suffered loss or injury are victims, but in some cases the near and dear ones are also the victims. For example, when we see rape cases, not only the person against whom the rape is committed is a victim, but the family of the girl is also a victim, because they also feel very bad and they also feel disregarded in the society. So they are also the victims of the crime. Now, can a victim of crime gets compensated in India? Yes, a victim of an offense can get compensated in India, but there is a procedure which need to be followed. So how can the compensation be sought? So the compensation has to be ordered by the court. Compensation has to be sought through the procedure that is established by the court. Compensation is awarded for the material as well as non-material damages. Material damages include medical expenses, cost of livelihood. Non-material expenses includes the pain, suffering, mental trauma. Especially in criminal cases, the victims can directly apply for the compensation, and thus it is the duty of the lawyer representing the victim to demand such compensation. Now, treatment of victims.
Yes, ma'am.
Yeah. So section 397. All hospitals, please underline, all hospitals, public or private, whether run by central government or the state government or local bodies or any other person, shall immediately provide the first aid or medical treatment free of cost for the victims of offences under section 122, 64, 66, 67, 68, 70, 71, 122 of Bnss. Okay. So, and also under section 4, 6, 8 and 10 of prevention of sexual harassment against children, and shall immediately inform the police officer about such incident. Now, next is witness protection scheme. So, not only the accused person or not only the victims are protected, but also the witnesses of the crimes are protected. Section 398. Every state government shall prepare and notify a witness protection scheme for the state with the view to ensure the protection of witnesses. For example, I saw that the murder took place. Okay. Now, I should also be protected because now my life is also in danger. I have to go to the court and I have to state that yes, I saw that the murder took place. Now, compensation to the person groundlessly arrested. Please underline. So, if a person is without any ground arrested, so this will be the process. So, whenever any person causes a police officer to arrest any person, if it appears to the magistrate by whom the case is heard that there is no sufficient ground for causing such arrest, the magistrate may award such compensation not exceeding 1000 rupees to be paid to the person so causing the arrest of the person for his loss of time and expenses in the matter, as the magistrate may think fit. In such cases, if more than one person are arrested, the magistrate may in the like manner award each of them such compensation not exceeding 1000 rupees as the magistrate may think fit. So all the compensation that is awarded under this section may be recovered as if it were a fine, and it cannot be so recovered. The person by whom it is payable shall be sentenced to a simple imprisonment not exceeding 30 days as the magistrate directs, unless the sum is sooner paid. So for example, if the person is wrongfully arrested and if the compensation is not paid, so in that case the person who has wrongfully made the arrest of such person will be kept in a simple imprisonment for 30 days unless he pays the amount. Now, order to pay compensation in non-cognizable offences. So section 400. So wherever any complaint of a non-cognizable offence is made to the court, if it convicts the accused in addition to the penalty imposed upon him order him to pay to the complainant in whole or part the cost incurred by him in the prosecution, and may further order the default of payment, the accused shall suffer a simple imprisonment for a term not exceeding 30 days, and such cost must include any expenses that is incurred in respect of process fee, witnesses or advocate fee, which the court may consider as reasonable. An order under this section may also be made by the appellate court or by the high court or by the court of session when exercising their power of revision. Now next is victim compensation scheme. So in 2009, the central government gave direction to every state to prepare a scheme which has an agreement with the center scheme for victim compensation. The primary purpose of this scheme is to provide fund for the purpose of compensation to the victims or his dependent who have suffered loss or injury as a result of the crime and who requires rehabilitation. Now what will be the quantum of compensation? So it is the court which orders the victims who suffered loss need to be compensated. Under this scheme, whatever a recommendation is made by the court for compensation, the district legal service authority or the state legal service authority, as the case may be, decides the quantum of compensation to be awarded. Now compensation in the case where the accused is not found guilty or the culprits are not traced. So when in the cases ends the acquittal or the discharge of the victim and the victim has been rehabilitated, then the court may make recommendation for compensation. So where the offender is not traced or identified but the victim is identified and where no trial takes place, the victim or his dependent may make an application to the state or district legal service authority for the award of compensation. Now who is to provide compensation in the above case? So the state or the district legal service authority shall, after due inquiry, award adequate compensation by completing the inquiry within 2 months. Also, it is the duty of the state or the district legal service authority to provide an immediate first aid facility, for example any medical relief and all, to the victim free of cost on the certificate of the police. Now treatment of victim of a crime. We have already discussed that all hospitals, whether private, public, whether run by the central government or the state government or by the local bodies or by any other person, shall immediately provide the first aid or medical treatment free of cost to the victims. So what to do in case of inadequate compensation? So if the trial court at the conclusion of the hearing is satisfied that the compensation awarded is not adequate for such rehabilitation, or where the case ends in the acquittal or the discharge and the victim has to be rehabilitated, then it may make a recommendation for the enhancement of the compensation. So when is the
Ma'am, what is the meaning of adequate and adequate, ma'am?
See, adequate means reasonable. For example, you have suffered a loss of 1000 rupees but you are getting only 100 rupees compensation, so it is very inadequate. So if you have suffered a loss of 1000 rupees, then you must get a compensation of 1000 rupees, then only it will be adequate compensation. Okay?
Yes, ma'am.
Yeah. So when is the compensation to be provided? So along with the duty of the offender, it is the duty of the state also to compensate the victims. Compensation to the victims can be provided. So at the conclusion of the trial, that is the order of the court, when inadequate compensation is granted by the lower court to the victim of the crime, the appellate court, when you go in appeal, it can enhance the compensation. So where the accused is not traceable, then it becomes the duty of the state to compensate the victim of the crime. Now Central Victim Compensation Fund Scheme. So the central government in 2015 formulated a Central Victim Compensation Fund scheme to compensate the determined. So every state has their own guidelines which decides the procedure. An attempt has been made by the respective website from which I took this to forth the procedure by examining different schemes of different states. So this is the standard procedure which one might follow. So first is making an application before the district or the state legal service authority. So an application can be made for the temporary or final compensation It can be filed by the victims or their defendant to the SHO of their area. SHO means station house officer, or who is the head of the station. So the application must be submitted along with the copy of FIR, copy of medical report, copy of death certificate if that incident caused the death of the victim. Then scrutiny stage. So now the district legal service authority will verify the contents of the claim, specific loss, injury, rehabilitation, and will take consideration into all these facts. Then they will decide the quantum of compensation to be given to the victim of the crime. So the quantum of compensation be granted is decided on the following factors. First is underline the gravity of offense and the loss suffered by the victims. Next, medical expenditure that is incurred on the treatment, loss of livelihood as a result of injury or trauma, whether the crime was single isolated or whether it took over extended period, whether the victim became pregnant as a result of such offense. In case of death, the age of the deceased person, his monthly income, the number of dependents, his life expectancy, future promotional or growth prospects, etc. will be taken into consideration. Any other factors which the legal service authority might deem fit. Now the methods of disbursement of compensation. So the amount of compensation so awarded shall be disbursed by the respective legal service authority in the same nationalized bank in the joint or single account. Out of the amount deposited, 75% of them shall be put in the fixed deposit for a minimum period of 3 years, and remaining 25% will be available for utilization and initial expenses by the victims or his defendants. In case of minor, 80% of the amount 80% of the amount so compensated or awarded shall be deposited in the fixed deposit account and shall be withdrawn only after the attainment of 18 years and not before 3 years of the deposit.